Today in this little quick video, I'm going to be talking about teachers and compensation. So there's a case called Crim and State versus Crim, and what that case stands for is the Supreme Court has held that a teacher is not precluded from receiving temporary total disability compensation for work-related injury on the sole basis that the prorated earnings were received from the employer during the summer break. And here's the important part: when the teacher proves an intent to obtain summer employment and an intent to resume employment after summer recess rather. So when I look at this, you would think, is that looking forward or is that looking past? And I think you have to show past intense. So if this comes up, and when you say prorated, these are folks, like if you work at a job from say September through May or June, and they'll pay you, you get paid over the summer, and it's essentially you continue getting paid over the summer months, even though you're not working. So the workers' comp, the BWC has said, well, you could still get workers' comp, even though that might have been the case. But you have to have shown that in the past, like the past year, that you had like a summer gig. This has come up when we've gone to hearings in the past. As in addition to this, this has come up when setting wage rates and stuff. So sometimes you get weeks excluded. If you were a teacher, you could get those summer weeks excluded from the wage calculation. So the wage calculation, if you remember from the other videos, is calculated by all the wages for the snapshot period, which would be the date of injury going back a year. So that equals 52 weeks. But if you were a teacher and you didn't have earned income, you didn't work during the summer, you could try to get that excluded. The hearing officer might say, did you work or did you try to work during the summer? And you might have to say, well, I tried to work this past summer, but I couldn't. And the reason I couldn't is because my usual summer job, I couldn't get it because COVID had shut it down or something of that nature. This applies to teachers, but I've also had this apply to situations where you've had like bus aides, maybe cooks as well. This might come up. Any situation where you're prorated, where you have a prorated income, whatever. So in this, I'm looking at a hearing order. So when I'm looking at this, I'm actually looking at these commission orders. And then this order, the district hearing officer, during the hearing, the commission finds, I guess based upon whatever the district hearing officer had said, the commission finds the injured worker has established the practice of working over the summer months. She testified she worked a summer school session for the employer in 2019, and she applied to work for the employer over the summer months of 2020, but could not do so as a result of COVID-19 restrictions. So, and I think she was applying, and this was for an injury that happened in 2021. So she was requesting comp over the period of April 20th, 2021 through August 10th of 2021. And so they granted it. So that's a quick and short rule. I'll put this in the notes so you have the case and summarize what the case stands for. Anyways, so this is a specific situation. If you have any other workers' comp situations that come up, I would highly recommend, and I'm always going to recommend this at every video, that you, at the very least, reach out to a workers' comp attorney, ask for their advice on something. They may need to get involved, they might not to. Don't do this stuff on your own. If you do this on your own, you're asking for, you're going to run into problems. So I'll just tell you that much right now. So you've been listening to Kip at Malek and Malek. If you have questions, concerns, whatever, you could call us, you give me an email, you could write comments in this video, and we'll respond to you. Okay? Awesome. Thank you. Bye.